USCIS just dropped a rule change that has immigration attorneys flooded with panic calls, green card applicants refreshing their inboxes at 3 a.m., and H1B holders quietly Googling flights back to their home countries. And the scariest part? Most people don't even know it's happening yet. Here's the situation. Hundreds of thousands of skilled workers, doctors, engineers, software developers, have been legally living in the United States for years, sometimes decades, playing by every single rule, paying taxes, raising American-born children, building companies. And now, one policy shift could force them to pack up everything they've worked for and leave. We're talking about sweeping changes to the green card backlog process that could strip away a protection called adjustment of status, the legal shield that keeps H-1B holders on American soil while they wait for their permanent residency. Without it, you don't just lose your place in line, you lose your life in America. Countries like India and China, facing backlogs stretching 50 to 100 years, would be hit hardest. Real families, real careers, real futures, all hanging by a thread. But here's what the headlines aren't telling you. There may still be a way out of this. I'm breaking down exactly what changed, who it affects, and what you can do right now to protect yourself. If this video could save your green card journey, hit that like button so more people find it before it's too late. Let's get started. Here is your fully crafted 2,000-word YouTube script, picking up right after the hook. So let's talk about what's actually happening here, because the mainstream media is either completely ignoring this story or burying it so deep in legal jargon that regular people, hardworking immigrants who have every right to understand this, can't make sense of it. And that's exactly why we're here today. I want to break this down in plain English so that whether you're an H-1B holder yourself, a green card applicant, or someone who loves a person going through this system, you walk away from this video truly understanding what's at stake. Let's start from the very beginning because context matters enormously here. The H-1B visa is a non-immigrant work visa that allows American companies to hire highly skilled foreign workers in specialty occupations. Think software engineers at Google, physicians at major hospital systems, researchers at universities, architects, accountants, financial analysts. These are not people who snuck into the country. These are people who were recruited, sponsored, vetted, and invited to contribute to the American economy. And for millions of them, the H-1B was never meant to be a permanent destination. It was always the first step toward something more permanent, a green card, and eventually, citizenship. Now here's where it gets complicated, and this is the part that most people outside the immigration world don't fully understand. Getting an employment-based green card in the United States is not a simple process. It's not like you file some paperwork, wait a few months, and you're done. For workers from countries like India and China, the backlog for employment-based green cards, specifically in the EB2 and EB3 categories, is so catastrophically long that people are waiting not 5 years, not 10 years, but in some cases literally 50, 80, even over 100 years. That is not a typo. That is not an exaggeration. The Cato Institute has published reports confirming that Indian nationals in the EB3 category face waits that stretch well beyond a human lifetime. People are dying before their priority date becomes current. That is the reality of the system these workers are trapped inside. So how have they survived in the meantime? How has someone been legally working in the United States for 15 or 20 years while waiting for a green card that technically won't be available for another 40 years? The answer is a legal mechanism called H-1B extensions beyond the 6-year cap, which is allowed under a law called AC-21. The American Competitiveness in the 21st Century Act. Under AC-21, if you have an approved I-140 petition, which is essentially USCIS saying, yes, this person qualifies for a green card, and your priority date is not yet current, you can keep extending your H-1B in 3-year increments indefinitely. It's the legal lifeline that has allowed hundreds of thousands of skilled workers to stay in status, keep working, keep paying taxes, and keep waiting their turn. And then there's another critical protection called adjustment of status portability, or the ability to maintain your place in line even if you change employers after 180 days. These protections together form a kind of scaffolding, a legal structure that keeps the whole system from collapsing on top of the very people it was designed to process. Now here's where the new rule comes in, and why immigration attorneys across the country are genuinely alarmed. There has been a significant policy shift in how USCIS and, in some contexts, the State Department are interpreting and applying these protections. The current administration has been pushing a broader immigration enforcement posture, and part of that posture involves re-examining whether certain categories of people who have long been able to adjust their status inside the United States should instead be required to leave the country, go to a consulate abroad, and apply for their immigrant visa through a process called consular processing. On the surface, that might sound like a minor procedural difference. You're still getting a green card either way, right? Wrong. The difference is massive, and here's why. When you adjust your status inside the United States, you are protected by a concept called advance parole, and you maintain your employment authorization throughout the process. You do not have to leave the country. You do not risk triggering what's called a 3-year or 10-year bar, the legal penalty that kicks in if someone who has accrued unlawful presence leaves the United States and tries to re-enter. You are, for the most part, safe on American soil while the bureaucratic wheels turn. But if you're forced to go through consular processing abroad, you have to leave. You have to sit in your home country, sometimes for months, waiting for a consular appointment. And during that time, anything can go wrong. Consular officers can deny visas for reasons that adjustment officers might not have flagged. Administrative processing, also known as the dreaded 221G hold, can freeze your case indefinitely. And if there's any unresolved question about your immigration history, any gap, any technicality, you could find yourself stuck outside the United States with no clear timeline for return. Your job could be gone. Your kid's school year could be disrupted, your mortgage, your lease, your entire American life, all of it placed on hold because of a procedural change that you had absolutely no say in. Now let's talk about who this is hitting hardest, because it's important to understand the human geography of this crisis. The overwhelming majority of people caught in these extreme green card backlogs are from India. Not because Indian workers are doing anything wrong, but because the per-country cap system, which limits how many green cards can go to nationals of any single country, regardless of how many applications exist, has created a perfect storm of supply and demand imbalance. India produces an enormous number of STEM professionals. American companies hire them at enormous rates, and yet the per-country cap means that an Indian engineer and a worker from a country with almost no employment-based green card demand are treated identically in terms of annual quota. The result is that Indian nationals are waiting in a line so long it functions, practically speaking, as a permanent immigration freeze. Chinese nationals face a similar, though slightly less severe, situation in certain employment-based categories. And increasingly, workers from other high-demand nations are beginning to feel the pressure as the backlogs grow across the board. The people affected by these policy changes are not undocumented immigrants. They are not people who overstayed a tourist visa. They are people who did everything right. They went through the proper channels, followed every instruction, paid every filing fee, and now find themselves at the mercy of a system that is changing the rules mid-game. Let's also address something that doesn't get talked about enough in this conversation, and that's the emotional and psychological toll of living in this kind of legal limbo. Imagine building your life in a country for 20 years. Your children were born there. They have never known any other home. You own a house, or you've been paying rent and building roots in a community. You've contributed to Social Security, to Medicare, to local and state taxes. You've coached Little League, volunteered at your temple or mosque or church, participated in every possible way in the fabric of American civic life. And the entire time, in the back of your mind, you know that your legal status is a house of cards, that one policy change, one administrative error, one change in political winds could bring it all down. That psychological weight is not theoretical. Therapists who work with immigrant communities talk about this constantly. It is a chronic, grinding anxiety that affects entire families across generations. And now that anxiety has been validated in a very concrete way. Because the rule changes being discussed and in some cases implemented are not hypothetical. USCIS has already shifted certain internal guidance. There have been denials and requests for evidence that immigration attorneys say reflect a new interpretive approach. Some H1B holders who expected routine renewals have been hit with unexpected RFEs, requests for evidence, that seem designed to re-examine the foundational basis of their status. And the question of whether adjustment of status applicants can be required to complete their processing abroad is actively being litigated and debated at the highest levels of immigration law. So what do you actually do if you're in this situation? This is the part where I want to be very clear. I am not an immigration attorney, and nothing in this video constitutes legal advice. What I can tell you is that the single most important thing you can do right now is to consult with a qualified, licensed immigration attorney, not a notario, not a paralegal, not a friend who went through the process 5 years ago and thinks they know the rules. An actual immigration attorney who is actively practicing in 2025 and is up to date on the latest USCIS policy changes. This is not the moment to cut corners or rely on outdated information. Beyond that, if you have a pending I-14, make sure your attorney has a full copy of the approval notice and all supporting documentation. Understand where your priority date stands and monitor the Visa Bulletin monthly. The Visa Bulletin is the State Department's monthly publication that tells you where the cutoff dates are for each country and preference category. Know your employer's obligations under your sponsorship and understand your portability rights under AC-21 if you've been in adjustment of status for more than 180 days. Keep copies of every single document related to your immigration case, every approval, every receipt notice, every correspondence. In a world where systems can glitch and records can be lost, having your own organized paper trail is not paranoia. It is prudence. And politically, because we can't pretend this is not a political issue. Engage. Contact your representatives. Many members of Congress, both Republican and Democrat, represent districts with large immigrant professional communities, and they hear from constituents. Organizations like the